Muy bien, pues en este panel, excelentemente conducido por Úrsula Indacuchea, con la participación de Marco Fandiño, María Fernanda Rodríguez y Nora Lucy, abordamos el estado de la justicia penal derivado de la pandemia y las proyecciones para un escenario post-COVID-19. Muchas gracias a nuestros panelistas. Les recordamos y les invitamos a interactuar, a que escriban sus preguntas, sus comentarios sobre el foro, sobre los paneles, sobre los temas, a través del sitio de internet oficial innovacionenlajusticia.mexicoevalúa.org y a través de las redes oficiales del evento. En Facebook México Evalúa, en Twitter @mexevalúa, en Instagram y en YouTube. A continuación, tendremos el panel denominado Justicia Predictiva, el uso de Big Data. Este panel estará moderado por Vladimir Cortés, oficial del Programa de Derechos Digitales de Artículo 19. Y participará Daniela Andrea Suárez Naranjo, directora ejecutiva de la Fundación Ideas Disruptivas de Colombia; Juan Corbalán, director del Laboratorio de Innovación e Inteligencia Artificial de la Facultad de Derecho de la Universidad de Buenos Aires en Argentina; y Fausto Santos de Moraes, abogado y docente en Brasil, quienes reflexionarán sobre las buenas prácticas en materia de justicia que usan Big Data y justicia predictiva, sobre la regulación en el uso del Big Data y las ventajas y amenazas de la justicia predictiva basada en Big Data. Bienvenidos.
Big data-based criminal justice. Good morning, everyone. I was listening to the English interpretation. It's a pleasure for me to be with you. I am Vladimir Cortés. I am the responsible of digital rights of Article 19 for Mexico and Central America. Thank you to Mexico for the invitation to moderate this table called Predictive Justice, the use of big data. And I would like to congratulate as well to organize together with the Howman Foundation such necessary spaces to analyze the role of justice and law faced to emerging technologies. I am also honored to share this dialogue and reflection space with such distinguished guests, with Daniela, Juan, and Fausto. This panel dynamic will be as follows. We'll have 2 rounds of participations. Therefore, each speaker will have about 8 minutes for the first block and 8 as well for the second block. Then we will remind everyone who is following this streaming that you can make your questions and that you can share hashtags Innovando la Justicia or in English Justice Innovation. This is the digital era and the legal disruptive era. We are in a historical milestone in a transit time, as Dr. Marisa was saying, as it was the case in the Middle Ages when they moved to modernity. Then we are placed at the center of the technical innovations that transform society and the image that the human being has of themselves. We have it, the era digitalis, a land in which we don't have a legal and geographical limits of the nation state. And then we have new opportunities open by a rubbish world. We have to be aware of the fact that, and I'm going to quote, the pact with a machine is not a one-way street. This goes around life and it reduces our life to a streamlined existence. We adapt to machines and then we have the risk of to forget what makes us human beings. Machines are cold and they do not understand about the truth, beauty, love, or dreams. In the end, The response of who is programming who will depend on whether we remain truthful to ourselves and we do not forget our human essence. And if we are capable to acknowledge in this, all of the beauty that an algorithm will never be able to capture. We are in a moment, therefore, in which the law must not just regulate the new, but as Dr. Barona was saying, to avoid that the last conquests by law are diluted in this digital world. So in this world of software and digital tools, we have to use this. And in this space, the algorithmization of logics, in which we have a new way to conceive the world, justice, law, and its modus operandi. The incorporation of artificial intelligence in justice has a gamut of options, and in here with the panelists, we are going to be depending on this, the creation of predictability models to determine projections for clients, the Pretoria Court of Columbia to improve the selection of protection actions, the judicial argumentation models, and as well as the conciliation, arbitration, judicial reports, agreement, negotiation mechanisms. In this moment, we will have the opportunity to explore these and other cases hand in hand with the experts. Therefore, these are incorporated in the justice, and then this can be seen essentially in prevention. It's here where we see the eruption of predictive justice and the criminal investigation, as it was seen in another of the panels. In the judicial decision making and sentencing, judicial with algorithms has questions of what they are, how they work, who is behind them. Algorithms are new, as Alvaro Pereira Gonzalez said. The actual risk of changing human risk in mechanical justice. If we think about algorithms as cooking recipes and some kind of ingredients, in this case, we will have data, big data, and through a series of instructions, we are going to obtain some results. Those results, Dr. Barona in justice at first has some unquestionable effects. We're going to examine these reflections and many more. So I would like to start this first round with 2 questions. What do you think are the best practices in justice affairs using big data and predictive justice? And the second question is, how can we regulate the use of big data for real predictive justice, and also one that protects and minimizes any potential risks that it can entail? First of all, I would like to give the floor to Fausto, who has 8 minutes now to share with us his reflection around these 2 points. The floor is yours.
Thank you for this presentation, Professor Vladimir. I am grateful to be here and join in all these important colleagues to speak about this topic of predictive justice and how we should reckon about this topic. I will try to answer these 2 questions you raised, and then I thought we should start talking a little bit about the Brazilian context, and then I bring now how Brazilian system is working with an artificial intelligence program. We have in Brazil the artificial intelligence program Victor in our Brazilian Supreme Court. Since 2018, Brazilian Supreme Court has been developing an artificial intelligence named Victor. The program is in charge of identifying, selecting, and classifying appeals to a certain set of issues. Such set is compounded by formal decisions which have collective binding. This procedure of picking and classifying is called broad repercussion. In 2004, this legal institute was created, improved by the private procedure code in 2015, and it has been working as a kind of precedent with the following characteristics ever since. First, the Brazilian Supreme Court recognizes one legal issue as a broad repercussion when the court had received many cases raising the same legal claim, and this could affect the Brazilian state socially or economically. Second, equal cases must be put together in the same legal group. Third, the court selects some petitions to be analyzed as a representative of the claim. Fourth, the Brazilian taken in these representative cases bend all the others. Fifth, the Brazilian Supreme Court builds a ratio decidendi through a legal proposition called thesis. Up to now, there have been around 1,080 theses. Finally, the thesis must hold all the cases with the same claim. Turn to the Brazilian Supreme Court routine. The court receives about 400 appeals daily. All of them are digitalized and make part of the electronic process. Many of these appeals are identified as a matter of broader repercussion. Curiously, the Brazil legal system has more than 80 million active lawsuits. In this procedure, one Brazilian Supreme Court clerk in charge of identifying, selecting, and classifying appeals takes up to 30 minutes to finish this process, with 75% of accuracy. The artificial intelligence program created can do the same task in 3 to 4 seconds, reaching an accuracy rate of 91%. Here, I must highlight the program runs operating just with the largest legal issues volume previously chosen. To estimate, there are about 28 of such legal issues. I will skip what I call here technical aspects, and I will assume that it is possible technically to have this legal classification about we have a legal premise and classify automatically, technically with artificial intelligence, some lawsuits. I will bring for us 3 aspects to discuss this classification trend. The first aspect is the regulatory aspect. The issue here is whether the following 2 points are in accordance with the Brazilian legal system. First, is it legally possible to decide a group of equal cases using the same decision as the main normative premise? Second, is there a legal prohibition for using technology to support or replace human decision? The Brazilian Constitution was amended in 2004 to admit broad repercussion as pointed before. In 2015, the Private Procedure Code was changed to create new way to hold legal decisions. By the Private Procedure Code, the judiciary must gather legal cases in a group and make just one decision binding all the cases. This should make procedure faster and more efficient. Consequently, there is legal ground to have just one decision for a group of cases. About the second point, despite of being possible to have a technological process to identify, select, and classify cases automatically, to one thesis of broad repercussion, what can be called as legal classification. The National Bureau of Justice enacted in 2020 the Regulation 332. Under this regulation, programs must not automatically perform legal classification, but just suggest this result to a judge. In fact, only judges must be responsible for the legal classification activity. The Brazilian Supreme Court program is understood in this sense as a supportive tool. Even though the regulatory definition seen above, one problem may arise when artificial intelligence is used to model legal reasoning and to create a premise for legal classification. This will be faced in the theoretical aspect. For this, the premise for legal classification is a content of legal thesis in broad repercussion that demands a translation of legal knowledge into computational programming. This translation may face the problem of hypernormatization. The hypernormatization may happen when factual or normative features which grounds a legal premise by artificial program uses do not adequately formalize the thesis. From this phenomenon, programs may not run based on a real pattern embedded in legal knowledge, but an artificial pattern that overfits factual and normative features.
Con de las características normativas y factuales como norma decidendi. Ahora, aquí el patrón está muy representado y se tiene que asumir de manera progresiva como un conocimiento jurídico incuestionable con base en la teoría básica del precedente. Es posible establecer que un patrón jurídico ignora dos mecanismos de actualización del conocimiento jurídico como la distinción y la anulación. Aquí terminan los dos aspectos y más adelante voy a hablar con ustedes sobre el aspecto filosófico.
Muchas gracias, Fausto. Desde luego, creo que se comienzan ya a dibujar estos dos elementos, sobre todo en la parte también regulatoria y los ajustes que se tienen que hacer de cómo interviene la inteligencia artificial en los procesos de justicia, ¿no? Como una herramienta de apoyo.
As a supportive tool. And now I would like to give the floor as well to Daniela to speak about the same two points. And right now we will have 8 minutes. So we can adjust for the next block. We will only have 5 minutes. The floor is yours, Neil. Thank you very much, Vladimir. In terms of good practices in Colombia, we had the opportunity to design the disruptive strategy against drug trafficking. And this has been a strategy that in terms of execution has left us many experiences and learned lessons because it goes to the practical aspect of things and not just a technical, conceptual, or philosophical aspect of things of big data. What did we understand from our strategy, and that's why we called it disruptive, is that we had to break up with a classical approach and we had to work with justice administrators, and not just in terms of looking for the responsible actors and go into the investigation, collection, sentencing, and also how we can stop criminal learning, which allows for criminals to survive and to have a high impunity rate in our countries as well. Then we have this strategy with projects that from science, from applied science, are going to destabilize the criminal networks, specifically in terms of drug trafficking. You already know Colombia has a big problem, historic problem, related to the production of chlorohydrate of cocaine or synthesis drugs which are not produced in our countries, or the cocaine chlorohydrate. And in specific terms of the big data analysis, we created an algorithm that allowed to identify the placement of big labs producing this product. And in perspective terms, if we intervene at one of these labs, what was the likelihood of another lab to be mounted again in a nearby area that in judicial terms we thought to have cleaned. And this is why is this important? Well, we have specific examples because in terms of transparency, when we conduct analysis based on data, well, we know that institutions we will have very important registrations of people who are part of our institutions go into the information. Well, entering information by mistake, some have differentiated criteria that we have to standardize, and we have a high black figure. And this is because our institutions, at least in Colombia, and I know some international experience, they have some operational goals in terms of strategic management that make officials sometimes to modify these figures. So then our intervention will not have an actual impact on the final phenomenon. We have to be very careful here and we have to be very transparent here. This information that we're going to be having must have as well validation in the field and an intervention with the key actors that allow us to have a triangulation so we can have an appropriate coordination with the high strategic elements which are clarify here something really important. It's not just the need to create algorithms, because it's going to take us to a space in which we are all working in terms of cyber defense and cyber security, but also we have to understand that the creation of those algorithms and the application of the science has to be directed to some very clear objectives in a judicial and operational terms, together with the army and the enforcement. We have to be able to define in a standardized way those goals, and we have established three main goals: a structural goal that allows us to understand the organization of those criminal networks, who are the ones operating and dynamizing them, and knowing that these organizations are used as a criminal outsourcing and not just as a highly identifiable heads, as we were saying before. And second criterion, corruption. People who are public civil servants, and they create both legislation and judicial advantages and economic advantages for criminal organizations. And the third element, which is also very important, is the economic financial criterion, how the goods created by those illegal economics, in our case, drug trafficking, end up completing a cycle to get to lawfulness. And which are those institutions that allow for these assets to be laundered and to go back to fed those criminal organizations? In such terms, our experience is the disruptive strategy against drug trafficking, and with the use of that information being very clear how we can contrast this in the field, also including the topic of counterintelligence. So we can clean the level of corruption that we can have within our institutions, and we managed to conduct a very effective intervention, just and not just in terms of laboratories and cocaine chlorohydrate, but also in terms of bioengineering, modifying this plant so it does not produce this alkaloid, changing the petrol and so we have to think about science and beyond the algorithm, and which are important and which classically have been instrumentalized so we can fight against organized crime. And an algorithm we created for laboratories. It's not that this was just it was not just some historical statistics for the concentration of heat, which and then we had to intervene in labs. What we did was to adopt a British technology, which is used for the identification of serial killers. And according to some variables such as closeness to hydrological sources, input providers, and the presence of illegal outer groups, so we created that algorithm, predictive algorithm, to know whether in a moment we could intervene lab-wide the likelihood for this to be rebuilt, and in which this will happen. In Colombia, we have a seasonality of 2 days, and we have tried this in the field when a laboratory is dismantled into 2 days. Criminals already mounting another one, and for this we have to be more efficient as a state, but we draw on such tools. Finally, for the second question, which was the topic of how to regulate this in a country, it's Daniela. I'm sorry, I'm going to interrupt you here. Maybe we can leave this part for the second.
I'm going to interrupt you. We are going to leave that part for the second block. And okay, I believe we are saying how we are using this from the district's attorney office. And now we are going to give the floor to Juan for him to make his comment in 8 minutes about these good practices and what are the elements in order to start. Thank you very much, Vladimir, and our colleagues. It is a great pleasure to be here with Daniela and Fausto. I will try to summarize in this 7 minutes and 46 seconds 3 aspects related to this question that you asked, Vladimir, and to Fausto and Daniela's question. First of all, and this is out of the experience of creating the cases Pretoria, Prometea, and another one that is going to be called Tucuy Ricuy in the Constitutional Court of Peru, which is about to be launched in 15 days, which is a prediction system for gender violence. And this is our 6th prediction system. And I'm going to try to talk from this place by having incubated 6 different predictive for 6 different issues. The first thing that I wanted to mention, because I think that this is related to the lessons learned, I think that it's very important to do a differentiation between small data and big data. For me, that is critical. One thing is to predict in small data and another thing to predict in big data. The second thing that I wanted to share with you is that to predict this forecast or different predictions imply to reduce uncertainty and manage uncertainty, because what an algorithm does is not to tell us the past, is an interpretation, an algorithm interpretation of the data from something from the past, and always the past is something that we cut out. And this is important to highlight because it seems that predictions are something like a diagnosis that we should follow, when actually, since they have certainty rates, they are usually provisions that are subject to different assessments before using that prediction. That is my first idea, because this is the step before regulation. Because if we know that the past that we're trying to predict is something that may have different nuances, it's not what we call the data set. It's the logic of interpreting this data, and it is clear that prediction is going to be a consequence of this other thing that we need to assess. And if it's not assessed or diagnosed by the officer that is going to use the algorithm, there is a robust bias from the competency standpoint. When we have tried, may I please share a screen because I cannot do it? When we have tried to do predictions with big data, we have seen that in Latin America, it's very difficult to find big data scenarios. In cybercrime, we may have big data things, as Daniela was mentioning, but regarding civil law, labor law, or commercial law in general, it's very difficult to get 5 million of something or 10 million of something. Usually what we get are thousands of data in the best case scenario. 10,000 or 20,000 maybe, because let's remember that when we are trying to predict, we detect certain segments that we can forecast, and we are not predicting in general what a court will rule. This is only something that someone that has not tried to predict a lot would say. So we need to find segments so that this algorithm may adjust faster and have a more efficient yield in the first stage when we are trying to train it. Now, I think I can share screen now. What I wanted to share with you is that when we're trying to train an algorithm, in 2017, we realized that if I put the case number and we got it with 5,000 rulings, we trained it with 5,000 rulings such as topic model, regression, and different topics that are machine learning and not big learning, we could achieve a high predictive yield, the 93% in percentage. We didn't have to apply a neural network. This is a technical issue. Well, in 2017, we found this with Prometea. So we put the case number and the system creates the case directly. So what it does is ask if I want to do a self-sufficiency control. In numbers, according to the Inter-American Bank, who did an audit to us, we had an audit in Prometea. They were there for 2 days, and we gave the Inter-American Bank the 8 data sets that we had for this source code. Then after that, the IDB had these numbers as they are published here. You can see it here. I don't want to overwhelm you with all these numbers. But in the Pretoria case, which was a similar approach, we found 2,500 rulings in health cases, and with 7 data sets, we had the rates on 91%. And the logic was of 202 workdays to 36 minutes. And we reduced the times from 202 days to 36 minutes. So this is the constitutional organization that receives the largest amount of cases in Latin America. They receive 1 million cases a year. These are numbers that not even Brazil overcomes in terms of courts. This is 1 million cases a year, and this is something that I had not seen before. The last thing that I wanted to share with you is that when we reason this prediction phenomenon, there are different ways of executing it. So I'm going to show you another way that we found recently, which is that we can upload a PDF file. This is another prediction that we did for the IDB for the review processes of individual contracts. This is a process that is also from an audit. And we upload a PDF file. This is another way of doing this algorithm. Instead of sending the system to go look for it, then I upload a PDF file. And when I do it, what the system does is create a report from reading the PDF. So it creates a report that I can download in a Word file. I could share it with you, but I don't want to go beyond my time. This is what I will say to finish up. What did we find in the small data that didn't happen in the big data? Greater rates of having correct answers, and also that with fewer amounts of data, we had a better performance. So my advice is that by default, we need to predict with small data. And when we cannot do it with that and with machine learning, not deep learning, then we can go to big data. We need to go the other way around than what is being done in the corporate world. In the corporate world, we start with big data and deep learning. But I would suggest that justice should begin with the classic machine learning with small data, and if we cannot do it, then deep learning. Thank you. Amazing, Juan. Thank you very much. I think that the last thing you mentioned and the title of this panel starts with this predictive justice and big data, but we are also on the need to rethink this approach. And there is also an element that you mentioned, the audits, how important it is when we are addressing